You will receive credit. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. No.
I'm telling you, like, she thought, like, I could not get up there.
I'm going to hand you the trial court certification that shows this
I would
was,
like to speak to a detective.
this was not an agreement, and so you waived your right to appeal. I need you to sign that with
I gave you
her.
hospital papers. I gave her everything.
I'm also
I had
handed
a
you,
doctor's appointment and everything. That's what I'm
I've got
telling
5
you.
more years that I could add on to that.
Oh, man.
I can give you up to 10.
Pause right here. Did you catch that? The judge just reminded Atkins she could face up to 10 years. That's not just courtroom chatter, it's a real legal leverage move. Judges often throw out the maximum penalty to test whether the defendant understands the stakes. What would you do in her shoes? Keep talking or stay silent?
Morning, Mr. Lewis. Thanks for being patient this morning. All right, ma'am, are you Devon Atkins? And Ms. Atkins is on probation for the 3rd-degree felony offense of injury to an elderly person. That's started at May 23rd of 2022. There was a motion to adjudicate probation filed. She entered pleas of true to counts 4 and 5. Does the state have testimony with regard to counts 1, 2, and 3?
Yes, the court would like.
Yep, I think I would.
Young man called, Mr. Cole.
Yes, ma'am. Good morning, Ms. Cole. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Ms. Coleman, would you please state your full name for the record?
Shakita Cole.
How are you employed?
I'm employed at Jefferson County Adult Probation.
And as a adult probation officer, is it your responsibility to supervise an individual on this court's probation by the name of Devon Atkins?
Yes.
Do you see Ms. Atkins in the courtroom here today?
Yes.
Can you point to her and identify her?
Right here in the blue jumpsuit.
Your may the record reflect Ms. Cole has identified the probationer Devon Atkins.
Record will so reflect.
And Ms. Cole, as with every probationer, when they are placed on the court's probation, are they given the rules and restrictions placed upon them and what they are supposed to do to follow the court orders?
Yes.
And each one of those in detail is gone over with them so that they understand everything that they're required to do, correct?
Yes.
Was Ms. Atkins so advised?
Yes.
At her intake?
She was advised at her intake and at a TTM at the Melton Center in person.
Okay, and describe for the court what a TTM is.
A treatment team meeting.
Okay, so in your opinion, Ms. Cole, as her probation officer, was Ms. Atkins fully apprised and aware of what she was required to do on probation?
Yes.
And were in fact a majority of those things intended to help her?
Yes.
Was she advised that she was to report to the Community Supervision Department when directed by yourself in the court?
Yes.
And did Ms. Atkins, based on your review of the file, fail to do that on multiple dates, including but most likely not limited to November 4th of 2024, November 19th of 24, and, and was that in violation of her probation order?
Yes.
Did you address that with her and inform her it is important to report if you have something coming up, you need to let me know?
Yes.
And did she do that?
No.
Was Ms. Atkins, as a condition of said probation, ordered to perform community supervision hours?
Yes.
And did she, and to report those to you?
Yes.
Obviously, if you do not know that she has completed them, even if she has, is that a violation of her probation?
Yes.
To your knowledge, based on your review of her file and your supervision of her, did she either complete the hours or immediately report to you? Sorry, I'm reading that. No wonder everyone's looking at me.
I was about to, I know, I was about to,
Community service. Well, that is in fact a condition of probation, right? Is it also a condition of probation that she is to report to you as her address and so that you know where she is at all times?
Yes.
And if she does not do that, is it impossible for you to locate her?
That's correct.
Did she in fact immediately report to you her current address?
No, she did not.
Most importantly, based on Ms. Atkins' underlying offense and her issues, was she ordered or did she attend the safety program?
She attended safety. She completed the unit placements and the residential aftercares, but each time that she went for the supported outpatient, she didn't complete. So she didn't continue.
Okay, and was that failure to provide verification of attending safety a violation of her probation?
Yes,
And did that go hand in hand with her failing to successfully complete safety, which is to include any aftercare programs?
correct.
And she did fail to successfully complete the entirety of the safety program as ordered.
That's correct.
And again, addressing those issues, is she ordered to submit at your direction and court's direction to alcohol and/or drug screening?
Yes, she is.
Was she ordered to do so on October 30th of 24, November 7th of 24, November 12th of 24, and November 13th of 24, and November 16th of 24?
Yes,
And to your knowledge, based on the review of her file, did she fail to do that?
she did fail to do that.
With respect to the entirety of Ms. Atkins' case, if I may, if this is the appropriate time, Judge, is there anything else? I know you and I have had a lengthy discussion about her that you feel would be appropriate for the court to know in conjunction with your testimony and the updated PSI?
The main thing is her mental health. She refuses to address that. We've made
And there it is, the curveball. Not only is Atkins skipping probation requirements, but she's also breaking one of the biggest rules: no contact with the victim. In this case, her grandmother. That instantly raises the emotional stakes. Do you think this was defiance or desperation?
appointments for her with Spinal-Top, and she didn't attend the appointments. She's 100% when she was out unmedicated. So that kind of interfered with her completing her services. And she maintained contact with the victim in the case. So
Okay.
that part, her grandmother was trying to be there for her because of the mental health difficulties. And that's the main thing that we were trying to get her to address.
Okay.
Can I address anything?
In a minute. Mr. Lewis, do you have any questions? Hold on, ma'am. You're going to get an opportunity, okay? Mr. Lewis, do you have any questions of Ms. Cole?
Just briefly, during your supervision of Ms. Atkins, were you able to supervise her at points when she was on her medication and not on her medication?
The entire time she has not been on her medication.
So she's been unmedicated this entire time?
Yes,
during
sir.
your supervision? Okay,
Anything else?
nothing else.
All right. Thank you, Ms. Cole. Any other witnesses with regard to the allegations? Based on the testimony,
Unless I may ask, Ms. Cole, Judge,
Yeah.
and you stated that earlier, Ms. Evelyn Thibodeau, I believe that is her grandmother, correct?
Yeah, exactly.
hold on, ma'am.
At some point in time in November of 2024, was Ms. Atkins violating the condition the court had imposed that she not to have contact with Ms. Thibodeau for Ms. Thibodeau's safety?
Yes.
Thank you, Judge.
Any questions about that? About
No.
the count, that's count 8 with the
Right.
contact? Okay. Then, at this time, based on the testimony, I am going to find count 1, 2, 3, 6, 7, and 8 true. Again, there were pleas of true to counts 4 and 5 previously. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, ma'am, Judge.
Any additions or corrections to that report?
No, from the bench, Judge.
Nothing from the state, Your Honor, unless Ms. Cole has something to add.
Do you have anything to add that's not already in your report?
No.
So the main thing I want to make sure, Ms. Cole, I have a notation here to ask is, you guys were aware of mental health issues and had opportunities for Ms. Atkins to participate in mental health services. Is that correct?
I made the appointments myself for her.
Okay. All right. Argument, Mr. Lewis?
Well, Judge, I think definitely from the updated PSI we have, as well as I think there was some issues from the jail. If you look at those issues and activity, I think that goes directly to her mental health state. Unfortunately, she has not been on a mental health caseload. I think that definitely would benefit her, as well as, being able to take advantage of any services that Spinal-Top inmate tomorrow may have, or any programs that probation deems appropriate for her. I have had conversations with her, and meaningful conversations with her, where she has addressed to me her desire to take advantage of those activities if those available to me. She did understand that she had the safety opportunity. It didn't go well, but I don't think the mental health issues were addressed, mainly just substance abuse at that point. I think if we can get a handle on that, or get some work done with her to address the mental health issues, I think she would do a lot better in this situation and can be able to complete this
I
assessment.
mean, it's hard when
Hold
the
on.
nationwide's not taking patients.
Well, it sounds like you had appointments that you missed that Ms. Cole made for you. What, did she go to regular Safe P or
They're not
special?
together.
Hold on.
Special needs.
So she's already been to special needs
Okay.
Safe P. So that was a whole 6 months plus aftercare of drug and mental health help. So Ms. Atkins, the problem is you're being given all the opportunities.
Yeah, but like I said, well, I don't know if I told you, I had an appointment in Port Arthur because I cannot get into Bowman. They're not taking new patients.
So you had an appointment that Ms. Cole set for you, at least one, how many?
Yeah, but it's not for medicine. It's for psycho. I'm not a psycho. I don't have those problems. I mean, some people do that. I don't know.
Well, you obviously we don't know what you need because you won't even go do the evaluation that it sounds like you haven't been on medication that would be, what?
Evaluation where?
At Spinal Top.
That's what I'm telling you. That's not, I don't have that. I'm not a psychopath. That is for.
It's psychopath, nobody's saying you're a psychopath, but you
That's
have.
what it's called, past program. I'm not a psychopath. That's what I'm
That's
telling you.
not what it's called, and that's not the reason it's called that, okay? If you had gone to your appointment and talked to them, then you would know what that was for, and you would know that it was meant to help you so that you could get on medication, stabilize, and not have the issues that you've been having. I'm going to find that you previously entered your, I'm sorry, Ms. Malfino, did you have anything to add?
No, Judge, I think that from my conversation with Ms. Cole, she's been gracious enough to offer to continue to work with her because I think she clearly sees the mental health issues. But as you can see, what Ms. Cole has been having to deal with is how the court has had to deal with Ms. Atkins today, and it's been kind of just this runaround circle.
Well, and in addition, I am going to find judicial notice of the court's file. Ms. Atkins was evaluated for competency to stand trial not that long ago. I think it was in January of this year. And I have that report. And the finding is that Ms. Atkins is competent, understands the nature of the proceedings, and is then just really making a choice not to follow through with what programs have been given to you, Ms. Atkins, to try to help you. So at this time, any recommendation as far as,
I have one more thing to say.
okay?
She is not giving me the information needed to follow up with those type of things.
Okay, well, I don't
She doesn't
believe
have
you.
them.
I don't believe you.
You don't
Ms.
believe
Cole
me?
would never say, go do something and not tell you where to go or help you get there.
No, she says she does not have a list of the community service.
I'm not worried about your community service. I'm worried about your mental health. And the fact that you're not doing what you need to, and you're still contacting the victim, and it's a serious case. And so I got to protect society, unfortunately, because you're not choosing to do
Well,
the
I
things
feel like
that.
I was gonna die, so I really didn't have much of a choice.
Okay.
It's my life in jeopardy.
I'm going to find that you entered your pleas of true to counts 4 and 5 freely and voluntarily. Again, I'm finding counts 1.
Boom, the gavel drops. 5 years in state prison. After all the warnings, missed programs, and courtroom back and forth, the judge finally seals Atkins' fate. But here's the real kicker: by continuing to talk back during sentencing, she almost risked more time. Lesson learned? Sometimes silence is your strongest defense.
1, 2, 3, 6, 7, and 8 true. Find sufficient evidence to find you guilty, and at this time find you guilty. Don't talk over. I'm about to sentence you to prison, and how you keep talking over me is about to start adding years onto that. Stop talking. It's just going to get worse. Do you understand? Okay. I'm going to find sufficient evidence to find you guilty, and at this time I'm finding you guilty of injury to an elderly individual. Sentence you to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. No.
I'm telling, like, she thought, like, I could not get up there.
I'm going to hand you the trial court certification that shows this
I would
was
like to speak to a detective.
this was not an agreement, and so you waived your right to
said I
appeal.
had
I need you to
hospital
sign
rights.
that with
I gave you
her.
hospital papers. I gave her everything.
I'm also
I had
handed
a
you.
doctor's appointment and everything. That's what I'm
I've got
telling
5
you.
more years that I could add on to that.
Oh, man.
I can give you up to 10.
Have 'em.
You need to stop talking so I can finish what I need to do, okay?
I'm telling you, I'm not guilty. That's what I'm telling you. I did not have a choice. I have went to the hospital and everything.
I'm handing you a
3
written
times.
admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered
I
against.
don't have a gun.
I'm not, just listen to what I'm saying. If you'll listen for a minute, you'll understand. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition.
I don't have a gun, man.
Good, then you
You're talking
don't-
to the wrong person. I'm Devon Atkins. I don't have a gun.
I'm required
No,
to
I'm
read that
telling
to
you, I
everyone.
don't know what you're talking about. I don't have a gun.
Good, then you don't have to worry about that. Go back with the bailiff.
Thank you.
Good morning, sir. You're Winfred Lamont?
Yes, Your Honor.
And Mr. Lamont has two cases, 25 DCCR 0234, charged with evading arrest or detention with previous convictions, and then 23 DCCR 1842, unauthorized use of a vehicle. And Mr. Chandler, what is the announcement?
We'll waive one more reading of the indictment, enter plea of not guilty.
Okay.
And then we'll ask for release.
All right, have you working on getting the discovery at this point?
We've received some of it, but there's some of it we're still missing. We're
Okay.
getting some videos, and then I think Mr. Coleman's on it, and they told me that he's in Hardin County as a special prosecutor.
He is. All right. Okay, so we'll just do a normal reset. That's about 30 days or so to give you some time to get with Mr. Coleman, get everything else hopefully that you're missing, and then we'll see if we can get an announcement.
Thank you, Judge.
All right, thank you, sir. You can go back with the bailiff. Camden Jackson. And Mr. Jackson is charged with engaging in organized criminal activity and cause number 25 DCCR 0114. And what is the announcement?
Your Honor, we have been getting discovery. We're just about done. I did all the work to go over there and grab the rest of it. But
Okay.
I also have talking to my colleague, and we've mapped out a preliminary plea.
Okay.
So I'm going to discuss that with my client and then discuss it with his family.
Okay, do you want me to hold it this morning for you to do that?
Well,
while
we
you're
just set him, I'm sorry,
Yeah.
Judge, we just set him up on the discovery portal midweek last week.
Okay,
He
so you
just-
need some time.
Yes.
He's hired on. The co-defendant has already pled. We've made a similar offer,
Okay.
probably to include ISF. He looks like he has some issues to clear up, maybe in some other counties. We're gonna try to package everything up.
Yes, Your Honor.
Okay, so just a normal reset is about 30 days or so to give you some time to try to work on that. We'll see if we can get an announcement at the next court
Yeah,
date.
that's
And
fine
he's
with me.
gonna run check
And I'm
on the
going to,
video right now.
Yeah.
Get another form of
Perfect.
receipt.
yeah.
Okay, thank you, sir.
Thank you.
You can go back with the bailiff. All right, Mr. Parker, do you have,
I've still got to take care of one, but I have one that's going to be, yesterday was like, doesn't want the deal, been refused, he's habitual, and now he's not, he don't want to sign that, and then he said, I'm going to take the plea, but he's playing games like, I guess, I'm being forced to. He says, it doesn't matter, I'm on a mental load.
what, who is it?
Walker the third.
Charles Ray Walker III, please.
It's just,
Well, we'll go through this and then see if it helps do anything.
it's weird, he's on parole and he's on probation.
So is there a parole hold?
I don't know that.
Can you look and see if there's a parole hold on Charles Walker, please? Charles Walker? Oh,
Sorry, Judge, I wasn't able to catch Miss Joseph in time yesterday afternoon. We'll back up to find that out for you on this. His probation officer, so
Oh.
he's kind of on dual.
okay. Good morning, sir. Are you Charles Walker III? I'm sorry. And Mr. Walker has 3 cases. It looks like, Mr. Walker, that you're on probation for two of your cases for burglary of a building. And then there is a new indictment of evading arrest or detention with the use of a vehicle. Motion to revoke your probations have been filed in both of those probation cases. Mr. Parker, excuse me, what is the announcement?
Your Honor,
just want to point out on the, I tried to make it clear to him on the new case, it's my understanding it's a third degree, but for punishment purposes, he would be that a habitual offender. He indicated to me yesterday he didn't think that because it's not the same crime that he's committed before that he's charged with, and I've explained that's not true. I don't know if he understands that or believes me. He indicated he did not want to take the deal, and then today I presented him the plea bargain rejection. He didn't want to sign it, and then so I filled out the paperwork for the plea, and he signed it all, but then he said, I'm only pleading because I have to. When I asked him if he's pleading because he is guilty, he couldn't say yes. I said, if you're not guilty, then you go to trial. That's what trials are for. And so I don't want to plead a man that says he's not guilty, saying he has no option.
Right. So, Mr. Walker, let me start with, go through real quick and look at that indictment in the new case. And we can make sure and have that cleared up as to what your potential punishment would be if you go to trial and if you're found guilty. So in cause number 25 DCCR 0212, that's the new offense allegation of the third degree felony of evading arrest or detention with the use of a vehicle. The offense date was December 16th of 2024. Your indictment alleges that you were previously convicted of burglary of a habitation, a second degree felony, September 18th of 2017. And after that was final, you were convicted of assault on a peace officer, a second degree felony, November 4th of 2020. 2 cases of assault on a peace officer on that same date. And what that means, and Mr. Parker is correct, that if you go to trial and those prior offenses convictions are true, you would be considered a habitual offender. And if you're found guilty, the range of punishment is a minimum of 25 years in prison up to 99 years or life. Do you understand that? I need you to answer out loud, please. Okay. And so we have a couple of options here. If you want to enter in some kind of agreement, you're welcome to do that. But if you do that in that case, you'll be pleading guilty. And I'm going to ask you a couple of questions if you do that. You're going to be under oath when I do it. And you're going to have to say, truthfully, that you are pleading guilty freely and voluntarily, that nobody's forcing you to do that, and that you are pleading guilty because you did what they charged you with. If you don't think you did it, then that's what a jury's for. We'll have a jury come in and decide. But I do want to make sure you understand the possible consequences and what your options are. And do you understand all of that? And is there a video that's...
And also, Your Honor, he's indicated that he's on a mental caseload, and he said, like, that's impacting his ability. I said, you haven't been deemed incompetent, as far as not being able to stand trial. And so
Is there anything that you don't understand so far about what I've...
No, I already said I plead guilty.
So, but here's the thing, you can't say I'm gonna plead guilty because I don't have any other choice, right? So when you, just like Mr. Parker said, he's not gonna bring you out here and say he's pleading guilty, and then you later go, well, Mr. Parker made me, or the judge made me, or I didn't have any other choices, because you do have choice. You can plead not guilty and let a jury decide. I just want to make sure if you want to enter a plea of guilty that you're doing so because you understand and because you are actually guilty. Give me just a second. Let me look at this administrative hearing. So it looks like you were on the high medium risk caseload, not the special, not a mental health caseload, but it was the high medium. There was 0 tolerance for non-compliant behavior, and then there was this new arrest. So I guess a couple things. I'd asked, is there a video that you've gone over, or have you received the video in that evading arrest or detention case?
I've not gone over a video with him. I don't think he disputes what the probable cause says. I think part of the dispute is what the charge is. He thinks that he should have been charged with failure to stop because he wasn't under a traffic stop, a traffic detention, I think he said, which I've explained to him what the law is. I mean, not.
Wasn't a very egregious evading, Judge, that it really meets the elements.
Okay. Well, I mean, and it sounds like there's all kinds of, so is there a hold?
Yes, ma'am. Yes.
He's got a parole hold also on the case that you're on
parole.
So I'm a little confused as to all the timing of everything and why he's on parole and probation. That doesn't make a
Judge, I
lot of.
looked at the dates trying to figure out what happened. It looked like he was sentenced to pen time on some cases and probation on some cases at the same time.
We're gonna blame it on Mr. Smith.
I'll have to, Judge. I'm sure there was a reason for it, but I just didn't see.
They used to do that in Orange County.
Yeah, but this is since I've been here.
Right.
Yeah,
Those burglaries and assault on the officers.
speak up.
The burglaries and assault on the officers happened at the same time. After I got out of TDC on parole, a month or two later, they
pled him to
charged me with those.
That makes sense.
So the dates of these were before, but they hadn't filed them. Gotcha. Okay, so that's why.
That makes sense.
Okay, so I'm just gonna hold your case for a minute. Go talk to Mr. Parker. If you wanna do something today, great. If not, we can either go through those motions and set it for a hearing on the motions to revoke. And then we can deal with that other case at a later date. I wouldn't,
Judge, if I may, it looks like, based on Mr. Smith's review and some discussion, that the offer was going to be 5 concurrent with that parole revocation, which
Correct.
should run out the next 5 years, if that's something that the court would not be inclined to accept based on the totality of the circumstances. If you'll let us know before we do the paperwork.
no, 5 on the evading.
Yes,
That was,
assuming that that will also revoke his parole for the next 5 years as well.
right. And then plea on the motions and everything runs at the same time. Yeah, whatever y'all wanna do is fine. I'll hold it. Y'all go visit.